My name is Nekima Levy-Pounds. I'm the president of the Minneapolis NAACP, a civil rights attorney and a law professor at the University of St. Thomas. And I'm here in opposition of Senate File 498. And quite frankly, I'm surprised that this one-sided bill has made it so far in our legislature, primarily because the issue of body cameras is such a sensitive one in the state of Minnesota and across the nation. As you all know, we experienced a major tragedy in the city of Minneapolis when Jamar Clark was killed by the Minneapolis Police Department, and apparently there was no video footage that showed the incident in its entirety. And obviously, had the officers been wearing body cameras, we would know exactly what happened. So it is something that is of great importance, particularly to the African American community, because we suffer disproportionate effects of excessive force and even death at the hands of law enforcement in the state of Minnesota and nationally. However, if a bill is going to be passed by this legislature, it needs to be the right one. A bill that strikes the right balance between privacy, transparency, and accountability. And unfortunately, Senate File 498 does not do that. It weighs too heavily in favor of perspectives of law enforcement at a time in which trust by the African American community and other communities of color in law enforcement is at an all-time low. We know that police officers have a very difficult job to do, that there are some great officers out there, yet we have seen patterns that are disturbing in terms of reports being falsified, information coming forward that directly contradicts video evidence. And this particular bill would only exacerbate situations like that because it allows for officers to review video footage before even having to submit written reports, statements, or conducting interviews. That does not reinforce the notion of transparency when an officer has a chance to review information prior to making some type of an official statement. The public doesn't have such an opportunity if they're alleging that they were abused in some way by police officers. Beyond that, the threshold under which the data would be available to the public is much too high. Number one, it would only be made public, generally speaking, if the footage was recorded on public property and it involves a police use of force that resulted in substantial bodily harm. That's a very high threshold. As a civil rights attorney, I receive numerous calls from people on a regular basis who allege to have been harmed by law enforcement at a level that may not rise to substantial bodily harm, but is just as dangerous in terms of how people are being treated or slammed to the ground or choked, etc. That data may not be made available to the public. And that is problematic. So again, that threshold is too high. Beyond that, there's too much discretion in this bill for local law enforcement agencies to set their own policies. If you look at subdivision 3, it allows for police departments to make decisions about when the body cameras will be turned on and off, when recording is mandatory, when there needs to be consent. That needs to be a matter of state law, as opposed to individual departments having an opportunity to make those decisions. We have seen circumstances in the state of Minnesota, for example, with the Metro Gang Strike Force, where they were allowed to operate without proper oversight, and they caused harm to numerous people. Here we have a situation in which we're allowing individual departments to set their own policies, and there's very little consistency for the public in terms of knowing what their rights are in a given situation. And so there needs to be state law. Rather than hastily enacting this bill, there needs to be an opportunity for the legislature to fully flesh out the challenges of this bill, the concerns that people are raising, and to set policy that will strike the right balance in the state of Minnesota. Communities of color will face additional harm if this bill is passed, because again, that balance is not being struck, and their voices have not been heard in this process, even though they have borne the brunt of excessive force at the hands of law enforcement. So I would urge this committee at this point to not move forward with Senate File 498, and in the interim, to take the time after the session ends to actually flesh out details of this bill to hear from communities of color and to bring forward something in the next legislative session that actually does strike the right balance. Thank you for your time.
Thank you for your testimony. Are there any questions for this testifier?
Madam Chair.
Representative Lesh.
Thank you, Madam Chair. Professor Pounds, can you clarify what you just stated about availability in a civil rights case? Is it your assertion that an individual who was a potential client or something could not get access to this video if the alleged harm was below the threshold as stated in the bill?
Well, it looks, I was referring to the data being made public if it doesn't rise to the level of substantial bodily harm or where the incident happened on public property. It looks as though there's a provision that allows for a court to, release the video, but there's also a question of what role an officer's consent plays in terms of whether or not that the complainant would have full access to the video or whether the officer would be redacted out or any information pertaining to the officer. So there does need to be more clarity surrounding that issue.
Representative Lesh?
No, thank you, Madam Chair.
Representative Schoen.
Well, Madam Chair and Professor Chief Schnell and the author made it very clear that the data of the officer is going to be available because it's going to be in the report that they used the camera. And the only exceptions to that is an undercover officer or others that already have those exceptions in state law currently today. So, I mean, the identity of the officer is going to be available if there's due process where there's a court hearing, as you described, to whether it's through civil matter or otherwise, they're going to have that information.
Well, and the reality is, I'm sorry. The reality is that we're talking about people who may not have access to an attorney right away, who are going to have to jump through lots of hoops and bounds because of their socioeconomic status to even be able to bring the matter to a court of law. There's not adequate resources out there, so we need to make sure that people have access to the data that they need, and then the public has a right to know. And it shouldn't have to rise to the level of substantial bodily harm for the public to have access to that information.
Representative Schoen. Representative Hillstrom.
Lots of questions.
Representative Hillstrom.
Thank you, Madam Chair. Professor Pounds, do you want me to call you Levy-Pounds or Professor
Levy-Pounds.
Levy-Pounds, Professor Levy-Pounds. So we spend a lot of time in the legislature talking about when there's criminal interaction. But a lot of times folks miss the interactions that happen that aren't criminal. For example, when law enforcement goes to a residence, maybe grandma's fallen in the bathtub and she's naked, we always try to figure out where the balance should be in terms of the data and who should get access to that. So I'd really like your opinion on some of those other pieces as well. I understand when there's criminal interactions or when there's allegations of misconduct, but can you help me understand what your position might be on some of these other interactions? For example, I get called out to an emergency, law enforcement gets called out to an emergency, grandma's fallen in the bathtub, she's naked. At what point should that be public, or should it not ever be public? And how do you think we should distinguish that in a bill like this?
Well,
Ms. Levy-Pounds.
Those types of issues need to be fleshed out in more detail. Obviously, as Rich Neumeister testified about, the focus on body cams has centered around issues of police misconduct and accountability and a lack of transparency within the system. That was my understanding in terms of why we would focus on body cams and implement such a system in the first place, although I have heard from at least one prosecutor that they are hoping that the evidence that comes forward through the video footage can be used in prosecutions of civilians. That was not the original intention, from my understanding, of body cams being put in place, but that's something that we're going to have to safeguard against, just as we have to safeguard against private information being put forward, like someone falling in a bathtub, or an issue that's not related to police misconduct that could be made public. Safeguards have to be put in place, and I do not think that passage of this bill would allow those safeguards to be put in place. Those hypotheticals that you referenced need to be fleshed out more fully.
Madam Chair.
Representative Hillstrom.
Thank you, Madam Chair. And just to follow up to that, so I actually have been looking at this Minnesota Coalition of Government Information and what information is public and what information is private. And one of the things that it talks about is that the data that reveals the identity of a juvenile witness can be withheld as private data only if police believe that the release of that data would endanger the witness. So, for example, law enforcement goes out to an incident maybe between mom and dad and children are present. Mom and dad know the identity of the children, right? So their identities wouldn't necessarily be protected under current law. So if there happens to be video footage of that, there's nothing under current law that would keep them from being on the 10 o'clock news. And that concerns me very much. And so I guess I'm just looking for some guidance or some thoughts from you about kind of some of these other issues. I understand where you're coming from, on the street, police interaction in the community, but this issue is much, much broader than just those interactions, and I'd like your opinion.
Well,
Ms.
the first
Levy-Pounds.
thing that struck me about the example that you just gave is the fact that, again, it leans very heavily towards police discretion in terms of deciding whether or not the identity or statements of a juvenile should be brought forward. I'm wondering about the parents and the young person who maybe doesn't feel as though they're in any danger. And because of the fact that there's already too much discretion that is inherent in this current bill, that is a cause of concern. I would like to see juvenile advocates actually having a voice in the process and helping to shape what the laws and policies should look like, as opposed to just relying on the police perspective. But your concerns are all the more reason to delay passage of this bill and to actually flush these issues out in the interim before the next session.
Representative Schoen.
Thank you, Madam Chair. I need to clarify something I thought I heard Professor Levy-Pounds state. You made a comment about using the video in prosecutions. Can you elaborate on that?
Yes, so I talked to a city attorney recently. We were in a conversation about this issue of body cameras, and that person talked about footage being available for prosecutions. And I raised concerns such as that's not the purpose of body cams, to record interactions with the public and then to turn around and to be able to use them as a part of a prosecution of an individual, at least from my understanding and perspective. So that raises concerns about whether this will be used more heavily as a surveillance tool towards the public as opposed to an accountability tool for law enforcement. And again, that's a balance that really needs to be struck. There are questions that have not been answered, and if you hastily pass this bill, it could cause much more harm than good. And this is coming from someone who was on the front lines after Jamar Clark was killed, knowing that there is a need for that type of footage, but wanting to make sure that it's done the right way.
Representative Schoen.
Thank you, Madam Chair, and Professor Levy-Pounds. So from what I'm hearing, your answer, are you saying that if I provide a couple examples, so there's a criminal incident where someone shoots at an officer or tries, there's an interaction where an individual is trying to stab his wife, or there's an assault that takes place, that the images caught on the body camera of an officer should not be able to be used for the prosecution of said crime?
I
Ms. Levy-Pounds.
didn't say in particular that the images should not be used. My point was about the whole purpose of body cameras. It feels like there's a bait and switch going on, because if the national conversation and our statewide conversation has been about the need for more transparency and accountability between law enforcement and civilians, particularly with regard to the use of excessive force or officer-involved shootings of unarmed persons, now to suddenly feel as though all of these recordings are going to be used in furtherance of prosecution of civilians, that is a cause for concern, because that's yet another tool that's being used without the proper safeguards and checks and balances being put in place. So that is more of my concern than anything. It feels like a bait and switch, and I want to make sure that the purpose for which we're putting forward these body cameras is actually being used for that purpose and not being tilted so heavily in favor of what law enforcement wants.
Representative Schoen?
Well, thank you, Madam Chair, and Professor Levy-Pounds. Can you explain how this would be different than squad cameras today then? I mean, we use squad cameras today to do both. That's our expectations, that those devices, and quite frankly, we're taking the lens off the dash or in the headliner of the squad car and putting it on either the chest or the glasses or whatever of the individual officer that's having that interaction. And the value is in both cases. And so I am one of the first people to say, well, I want to wear one. I want to be accountable to you. I also want the world to see that our interactions, in my perspective, are, 99.9% good, and those 0.01 need to be dealt with. They shouldn't be in our profession. But we have those, we're doing this today. We use video today. I take umbrage with your statement that this is a bait and switch, because I don't believe that to be the case. I've never heard that as being the sole instance, but I also believe that it is part of it. And so I have a major disagreement with saying that this is a bait and switch. But I will say this, that we had informational hearings on this. This started coming up in 2013. I clearly, if you've watched the floor sessions, I've made it pretty clear with how I felt about the fact that we're here 2 weeks or 13 days left of session, and we're actually getting the first chance to vote on this in this committee. I think we should have had the opportunity to vote on this and work on this and be able to bring amendments to the bill and have this committee make those votes early on in session so that we could have this discussion as well. It's unfortunate that we're doing this today and this late, but it does need to get done. We do need to move forward, and we can work on things in the future. I mean, we do come back every year because we find things that we've done in the past, even if they're my own. If I've made an error or think that something needs to be fixed, then I'm all good. I'm 100% supportive of that. But to leave this open today is for the reasons that even Representative Hillstrom brought up and various others, we won't have that accountability in many communities because they won't purchase them until we do that. And I don't think that that's a better measure either.
Madam Chair, I think that it's a better measure than hastily enacting legislation that is not going to strike the proper balance between privacy, transparency, and accountability. And, it's okay for us to agree to disagree about my use of language of bait and switch, but I stand behind it. Because if the national conversation is focused on police accountability, and now we have prosecutors who are more heavily focused on culling this data to use in prosecutions, that needs to be made clear to the public. But I also believe that that's a sidebar issue from what we're talking about here, which is the fact that the standards are not clear because of the fact that many of the police departments and law enforcement agencies are going to have a chance to set their own policy. So even the example that you mentioned regarding if data were used for a prosecution, if they're in a jurisdiction where the officer used his discretion to not turn on the camera, then if you live in Hennepin County or the city of Minneapolis, then what's caught on tape is going to be different from what's in St. Paul and Ramsey County. And that's a problem. So at the end of the day, it's more important to take the time and to do this right than to hastily enact legislation that is going to cause more harm than good.
Representative Johnson.
Madam Chair, I got a little just puzzled at a statement that was made dealing with not being able to, the subject not being able to view the video. If somebody has a complaint against an officer or a question about civil rights or how they were treated, the squad camera video, what this bill says as well, they have a right to go view it. And they will be given that opportunity to see that. It cannot be put out in public, but the individual involved does have a right to see that. And if they want to bring a lawyer or somebody with them, they can do that. They are going to have accountability. I've talked to many chiefs and many sheriffs across this state and in many other states. What they found out when there's video available, 95% of the complaints are dropped as soon as video's even, they found out there's even video. And of the 5% that are left, 95% of them are dropped as soon as the person watches the video and realize usually they were intoxicated and they did some pretty stupid things to that officer and realized once they were sober that they were in the wrong. And the officer was usually very polite and very courteous. And as it goes along, I have to correct Representative Schoen, it's not 0.01% of the complaints against the officers that are found to be correct. Nationally, it's 0.002%. So it's very few complaints against the officer nationally are found to be true. Now this video camera, the video, I want it to be used in court because then we're going to have the most accurate information for the prosecutors to use, whether it shows the officers are right or they're wrong. I know of one case in my area where an officer's charged a person with a gross misdemeanor, but it did not conform with what the video had. The prosecuting attorney dropped the case over the objection to the officers. The officers kept insisting, but viewing the video showing that the officers were wrong, the prosecuting attorney did not go forward with the charges. So this video is important to make the most accurate information for the prosecutors. And so there is accountability in there because the person involved with the video, the subject of that video, has a right to watch the video and see that video.
Madam Chair?
Ms. Levy-Pounds.
Yeah, so if you look at the delete all provision that's been brought forward, my questions about that arise from subdivision 4, where under Part B, it says subjects of portable recording system data, including peace officers, must be provided access to the data to the full extent required by this chapter while the data is retained. If a subject of private or non-public portable recording system data requests access to the data on any other subjects documented in the data who have not consented to the data's release must be redacted if practicable. Part of the question has to do with a peace officer being considered a data subject and whether they would have discretion, at least under this delete all provision, to have that information redacted. And again, that's something that needs to be fleshed out. In terms of what you were saying about the complaints being dropped after people review the videotape, I think that that's wonderful. As a matter of fact, I support body cameras in general, but I do not support Senate File 498 for the reasons that I've set forward. And some of the conversation is a detraction from the concerns that are raised about the levels of discretion that individual law enforcement agencies are going to have if this bill is passed without there being consistent state law across the board. So it is unfair that if the Minneapolis Police Department decides to allow consent in certain circumstances and that video recording is made, but if the police department in St. Paul have created a different policy, that information will not be available. And beyond that, in the city of Minneapolis, we see a number of complaints that are not only not being dropped, but that are the subject of excessive force lawsuits being settled. So over the last decade, at least $20 million in excessive force complaints have been settled by the city of Minneapolis. That points to a much larger systemic problem that needs to be addressed.
Representative Johnson.
I understand, Madam Chair, Professor, I understand your concern, but unfortunately, a lot of peace officers don't have a say in those lawsuits for excessive force. A lot of them did not have body cameras or squad cameras showing that they did nothing wrong. The city, in their ultimate wisdom, decided just to settle to get rid of them, and that's a black mark on great officers that have cost them their careers. That's why this is needed.
Well, I don't know those
Levy-Pounds.
circumstances, so as an attorney, I'm not going to jump to conclusions about why the city is settling those cases, but I know that at times there is documentation. There is sometimes cell phone footage and other information that's used. At the end of the day, as I said before, I support the use of body cameras if policies and laws are implemented that strike the right balance, and this particular law does not do so from my perspective.
Representative Johnson.
Madam Chair, if an officer uses excessive force, that person should not be an officer. They should be punished to the full extent of the law. The problem is we've gotten into a world of lawsuits. Everybody's suing everybody for everything. Whether it's right or wrong, I'm not going to be the one to say. But we've had some great officers have their careers destroyed because of false accusations, and departments, just to get rid of the lawsuit because it's cheaper than fighting it, have given up that officer's career without an officer having a say in it. That's what I'm upset about. And unfortunately, with what's going on, we're losing a lot of good officers in this state. And we have probably the best officers in the country in this state. And we need this bill, and we need this bill now, because it not only protects the public, but it protects the officer from frivolous lawsuits.
And on that,
Ms.
we can
Levy-Pounds.
agree to disagree. My position is very clear, and I do want to thank this committee for your time.
There's a couple of other folks, I think, that have questions. If you have the time, Ms. Levy-Pounds. Representative Zerwash, you're next on the list. He's passing. Representative Lesh.
Thank you, Madam Chair. I just wanted to state, Professor Levy-Pounds, that this bill is not a bait and switch. This bill...
I didn't say that this bill was a bait and switch. I said the difference has to do with the purpose of body cameras supposedly being about accountability and transparency, and having a prosecutor who said that they're focused on the information being used in prosecutions, not in police accountability issues. So I just want to clarify that I did not make that statement that this bill is a bait and switch.
Representative Lesh.
Thank you, Madam Chair. Professor Levy-Pounds, just so you know, the language contained in this bill has been what's been talked about around here for years. Okay, and it is largely written by and for law enforcement, and to their credit, they've been very effective at lobbying, and they got some talented people lobbying, some good folks, but we haven't necessarily had an effective pushback to find that middle ground, which is why we've ended up with a bill that's mostly championed by law enforcement here. But you should know that that's been the case for a while around here. Before this bill, that stagnated because we were still talking about license plate readers. Same thing happened with license plate readers. License plate readers stagnated while we were talking about cell phone exploitation devices. The same thing happened to exploitation devices. So just so you know, when I've had folks of mine come into my office, activists like yourself, who say, well, let's get those body cams out there. I said, have you read the bill that's out there? And they said, well, no, we want body cams out, to create accountability. I said, well, just go read the bill and then get back to me. Word needs to get out there about that balance, the balance that's been suggested. It's not totally balanced, I don't think, but I would hope that when you leave here, that you really do let people know that if they want a balanced solution, they need to weigh in more, because it really hasn't happened that much in the years that we've been working on issues like this. That's all, Madam Chair.
Any other questions for this witness? Seeing none, thank you for being here. I appreciate it.
Thank you for having me.